I have a suspicion that everyone only started hearing me now. Good morning, everybody. Very warm welcome to you to the Family Law Roundup, June 2025. It is absolutely lovely to see all of you here today. I look forward to running through the 22 very interesting judgments that emanated from our courts in June 2025. Can I just see by a round of thumbs up, can everybody hear me and can everybody see me? If you can just confirm, that would make me very happy. Okay, fantastic. We've got a whole lot of thumbs ups. Folks, I see there are quite a few AI note takers in the room. Obviously, just because this is our IP, we are unfortunately not permitting AI note takers. So I have removed most of the AI note takers from the room. However, fret not, the meeting will be recorded and you will have an opportunity to see our notes, including my opening slide, which I see says May. But rest assured, this is the roundup for June 2025. Righty, folks, think legal knowledge open to everyone, specifically legal knowledge. As you know, legal services are a commercial endeavor. However, legal knowledge, we believe, should be open source and open to the public. And that is why we do these types of events from time to time. And we facilitate dialogue, WhatsApp groups, webinars, etc. And we are absolutely thrilled to have all of you on board with this endeavor. Let me quickly see. I've got some people waiting in the lobby. Apologies for those who were waiting in the lobby. I have added you to the meeting. Right. For those of you who are interested in learning more, seeing more, go to thinklegal.co.za. There you can register for events, join our WhatsApp groups, purchase resources, and view past webinars. That's thinklegal.co.za. For those of you who are here for the first time, you will know that attendance at this webinar is absolutely free of charge. You are most welcome to attend, and it will not cost you anything but your precious time. However, as with all free services, we do put in a few ads here and there just to tell you about some of the things that we are doing and to invite you to get on board. One of the initiatives with the Family Law Roundup is our optional course pack, which is 300 Rand. It gives you the summaries of all of the judgments that we will go through. It gives you a bundle of all of the judgments, and it nets you 2 SARM or social justice CPD points. So for those of you attending for CPDs, please ensure that you pick up the course pack. What I'm going to do to that end is I'm going to paste some links in the chat box, and you are welcome to follow those links. First off, you can visit our website. Secondly, you can register for our upcoming CPD training, which I'll tell you a little bit more about. And then the link is also there to purchase the course pack and join our WhatsApp groups. I'd like to tell you all about our newest CPD accredited training, civil procedure for family professionals, specifically divorce. This is happening next week, 9th and 10th of July from 5:30 to 8 every evening, and it gets you 5 SARM CPD points if you attend. Now, what we have noticed since the coming into effect of the mandatory mediation directive in the Gauteng division is that there is a knowledge gap between lawyers and non-lawyers when it comes to family practice. This webinar training has been designed to bridge that knowledge gap. It is not a get out of your lane training. It is a training designed to ensure that we can all work in the same ecosystem. Specifically for divorce, We know that everything in a court-annexed process is rooted in civil procedure around divorce that sets the stage for anything happening of and concerning the matter, including but not limited to mediations, forensic investigations, financial investigations, etc. So this training, 9 and 10 July, 5:30 to 8 SA Standard Time. It is online via the Microsoft Teams platform, $8.50 per person. It gets you 5 SARM CPD points. It's designed for mediators, candidate legal practitioners, mental health professionals, and legal professionals who seek a better understanding of the divorce process. It's a 5-hour training, as I said, intended to bridge the procedural knowledge gaps in divorce matters. Successful participants should be able to understand the different stages of divorce litigation, identify key documents and procedures, recognize the roles of, for example, the family advocate and the sheriff. They should be able to understand Rule 43, pleadings, other relief mechanisms such as interlocutory applications, applications to compel, etc., and then understand how civil procedure intersects with children's matters, domestic violence matters, etc. I have pasted the link to register. Thank you, Pratima. I'm also looking forward to seeing you at the course. It should be quite a nice one. And as it always is with our new courses, the first round is always very, very interesting and very interactive as we find our feet going through it. But it should be a very, very fun one. So you are welcome, folks, to follow the link and register for that course next week. As always, ThinkLegal is supported by Lawbox Practice Management Software and my dear colleagues with endless patience at Vermeulen Attorneys. Right. And so the roundup begins. We have 22 judgments to get through this month, going all the way from divorce through contempt of court, Rule 43, children maintenance, procedure, customary marriages, and then finally one on surrogacy. They span all of the high courts throughout the Republic of South Africa, and they are very, very interesting. Starting us off this month is PLB versus LRB. It emanates from the Gauteng Division in Pretoria. It was delivered on the 4th of June 2025, and the judge was Domingo A.J. For those of you following along in your summaries and your bundles, you can find them obviously on page 1, and that is in respect to the bundle and the summary. For those of you who have purchased the course pack, you will see that not only do our slides look a bit different this month, we have also updated our summaries to include something new, which I'm going to share with you. For those of you who have never purchased the summaries, I'm going to run through PLB versus LRB so you can see what the summaries look like if you are considering getting it as a practice tool for yourself. So, folks, you'll see I've shared on the screen the PDF. As you can see, we have the citation on the left-hand side, PLB versus LRB. It's Domingo A.J., Gauteng Division, Pretoria. As our overview headnote says, it revolves around a divorce, variation of a settlement agreement, trust, pension interest, condonation, and joint estate division. Now, this matter is a post-divorce dispute over a clause in the settlement agreement which was made in order of court all the way back in 2018. The applicant approached the court to vary a clause which provided for the transfer of the matrimonial home to a trust for the benefit of the children, and instead sought a type of actio communi dividundo relief for the sale of the home. She also then sought the appointment of a liquidator and receiver to divide the remainder of the joint estate. Then the respondent counterclaims, brings a counterclaim to access 50% of the applicant's pension interest and to amend the parties' liabilities for the marital debts in respect of the erstwhile joint estate. Both parties quite lackluster in launching their applications, obviously. As I said, 2018, the divorce was made an order of court or the settlement agreement. So obviously the court dealt with the issue of condemnation on both sides. Now, what is dealt with under aspects covered in this case? Rule 42(1)B, which is obviously a variation of orders on the basis of patent error or omission. Principles were restated from Grootboom versus National Prosecuting Authority, which is the requirements for condemnation, Maharaj versus Maharaj, Gillingham versus Gillingham, and that's appointment of liquidators trustees. Section 7(8) of the Divorce Act, as we know, that deals with pension interests in divorce and the mechanism for the court to make an order that there be a division of pension interests. And then Plascon-Evans, as we know, which is factual disputes. And then finally, principles restated, Eek versus Parsons and Kotze versus Kotze. Now, what you will see under our outcome portion over here, I've added a little section which I think I almost want to kick myself for not having done this earlier, and this is just setting out what the court held in the matter. The application to appoint a liquidator was dismissed, the counterclaim was dismissed, the trust was ordered to be registered, and the trustee appointed within 3 months. Now, what was interesting about this is that neither of the parties had asked for that relief. The court, miro motu, of its own accord, gave the relief. So the court held that the divorce settlement providing for the creation of the benefit of the trust was not void but incomplete. It rejected the applicant's attempt to vary the clause on the grounds that doing so would deprive the children of a long-term benefit, i.e., a bond-free home. The court found that the proposed variation, i.e., the sale of the home, would only serve short-term financial needs, and the respondent's claimed pension interest was dismissed as the pension had already accrued and was no longer a pension interest under Section 7(8). The respondent's claim regarding joint debts was also dismissed due to the finality of the original settlement agreement. Accordingly, court upheld the clause regarding the trust, and then ordered the registration of the trust and the appointment of an independent trustee. Once again, interesting, neither party sought this relief, and the court did it miro motu. Our notable quote from the judgment, paragraph 83, the court says the following: having regard to the terms of the settlement agreement and the evidence placed before this court, there exists, in my view, on an application of the law referred to in this judgment, no reason why the court cannot intervene and direct the appointment of a trustee to give effect to clause 3.1 of the settlement agreement, as it would be in the best interests of, in the interests of justice to protect the best interests of the two children born of the marriage who are the beneficiaries of the trust, whilst the applicant's application and the respondent's counterclaim application fall to be dismissed. The court going of its own accord appointing a trustee and directing that the trust must be registered. So for those of you who purchase the course pack on a regular basis, you will see this new section, the held section, which I think is a welcome addition to the summaries. For those of you who have not purchased the summaries before, this is what they look like, and it will give you an idea on whether or not this is something that would interest you in your practice in the future. The link, obviously, for the summaries in the chat bar for those of you who are inclined to pick them up. Sales pitch over. Let's go on to DM versus DM 2025 for SA183GJ. Now, you will note, folks, that this is Friedman AJ, South Gauteng High Court, and the date on this judgment is the 28th of January 2025. Summary page 2, bundle page 26. You will note the time discrepancy is because this matter has now been reported. It was delivered in January 2025, and it was reported in June of 2025 in volume 4 of the SA Law Reports, which just highlights once again, folks, the importance of keeping our eyes on unreported judgments. Now, what did DM versus DM deal with? It dealt with an accrual divorce and a Section 7 notice. When is it necessary for the parties to calculate the accrual? Now, you will know under Section 7 of the Matrimonial Property Act, either party can, when it is necessary to determine the accrual, give notice to the other party to furnish full particulars of their estate. The applicant launched an application to compel, respondent opposed, court then had to decide when it is necessary for the Section 7 notes to be given. When can it be deemed to be necessary for the accrual to be determined? The court ordered the respondent to respond to the Section 7 notice within 20 days, and costs were awarded. The court held that while a Section 7 notice or Section 7 of the MPA imposes a duty on spouses to disclose estate particulars, courts retain a discretion under Section 173 to regulate their own processes. The discretion allows courts to delay or refuse disclosure in appropriate circumstances. However, in this case, there was no reason to delay disclosure. The respondent had failed previously to disclose his financial position, and the court found that the notice sought only what Section 7 contemplates. In the premises, the court ordered the respondent to respond to the Section 7 notice within 20 days. Now, an interesting judgment, certainly from Friedman A.J., our notable quote can be found in paragraph 51, where the court says, "To tie everything together, I wish to say something about what the courts are trying to tell spouses in the catch me if you can cases. They are saying that full disclosure means full disclosure. This can be done without waiving legal arguments and without prejudicing one's case. So, for instance, a Section 7 response, which was truly in good faith, could be formulated as follows. The spouse could say, I have X, Y, and Z assets in my name. Furthermore, there are the following assets which on the version of my estranged spouse in the particulars of claim would arguably fall under the category of beneficial ownership. The assets could then be identified, and the spouse could then make it clear that it will be argued in due course that they should be excluded." That was DM versus DM, Friedman A.J., South Gauteng High Court, dealing with the issue of Section 7 notices under the Matrimonial Property Act. Right, next up, folks, we go to RVB versus JVB. This judgment is all the way back from 19 November 2024, but it has now been reported in the SA law reports as 2025 for SA 297 FB. The quorum in this matter, Greylan Kutzer AJ, penning the judgment, Chesiwe J concurring, summary, page 3, bundle, page 48. This is a judgment which is quite possibly moot because of how things have already played out in the Constitutional Court. However, it deals with an amendment of a pleading to incorporate a Section 7.3 redistribution claim based on EB versus ER, our Greyling judgment from way back when, and it took place between the judgment and the amendment of the various acts, and whether the appellant was entitled to amend her pleadings in this instance. The Corte Quo had refused the amendment. The High Court, sitting as a court of appeal with two judges, Greylan Kutzer AJ and Chesiwe J, upheld the appeal and allowed the amendment. I'm not going to share the held section and all of the aspects covered, folks, anymore in the free version of this webinar. Unfortunately, I have gotten wind that many people are recording, transcribing, and then circumventing the need to support us for our summaries. So if you would like the summaries, please do support us. They are $300. It's certainly not going to break the bank, but unfortunately, we're not going to go into big detail on aspects covered and the held section in future, just to protect our IP. Notable quotes, however, I'm more than happy to share with you. And in RVB versus JVB, the notable quote is as follows: properly construed, paragraph 5 of the Constitutional Court order limits the retrospective application of the invalidity to matters where a final decree of divorce had already been granted. Alternatively, where the marriage has terminated through the death of a spouse. The immediate prospective application cannot found a basis to undo that which had been done at the termination of the marriage, either by death or by divorce before the date of the order. If the Constitutional Court wanted to exclude pending matters from its order of perspectivity, it would have done so in explicit terms and reasons. That is RVB versus JVB, essentially telling us that divorces which were already pending before EB and before the amendment to the legislation in respect to the Section 7.3 claim can still introduce those causes of action by means of amendment, provided that the divorce has not yet been finalized. Next up, folks, we go into the realms of contempt of court. 6 June 2025, EJL versus HJCL, and that is Mpama AJ. Summary page 5, bundle page 60. Now, this is a leave to appeal judgment for a applicant wishing to appeal a judgment in respect of contempt of court, or a finding of contempt of court. The applicant sought leave to appeal. The original matter involved a dispute over the binding nature of an existing order, with the applicant's alleged non-compliance with that order forming the basis for a finding of contempt of court. In this instance, it's a very short judgment, folks. It was considered in chambers based solely on parties' written submissions, and the application for leave to appeal was dismissed with costs. So this, obviously, as I say, it is leave to appeal against a contempt finding, and paragraph 5 of the judgment is quite instructive. The existence of a valid court judgment is a matter of common cause between the applicant and the respondent. The judgment dealt with the reasons why the court is of the view that the applicant is bound by the court order despite his pending application in the magistrate's court for a variation of the order, and why his conduct of non-payment is contemptuous. New issues were raised by the applicant in his heads of argument. It is trite that such is not permissible. Application for leave to appeal dismissed with costs on scale B. This appeal, obviously, in respect of a finding of contempt of court. Only one contempt matter this month, or last month. It seems that people have been behaving themselves for the most part. Next up, we go into Rule 43 territory, folks. We have 3 Rule 43 matters to share with you this month, all 3 emanating from the High Courts in Gauteng, 2 Johannesburg matters and 1 Pretoria matter. The first Rule 43 matter, and I just realized all of you can see all of my notifications popping up on my second screen. Sorry about that, folks. The first matter, HNC versus SJC. The judge is Adams J. You can find it in your summaries on page 6 and in your bundle on page 64. The matter dealt with a divorce. Well, obviously, it's a Rule 43. Interim maintenance. It dealt with means of the respondent. It dealt with capital claims under Rule 43 and a contribution towards legal costs. That is just our little head note there. Applicant sought interim maintenance of 53,800 Rand per month, escalating by CPI, continued payment of direct expenses, lease and rental payment of 18,000, capital amount of 193,000 Rand for household furnishings, and a contribution of over 950,000 Rand towards legal costs. Respondent obviously opposed, citing reduced income, illiquid assets following the sale of his company. Court was called upon to determine applicant's reasonable maintenance needs and the respondent's ability to meet them. The issue of capital settlement or capital claims under Rule 43 was dealt with. I will mention that to you folks. The outcome is that the court ordered 35,000 Rand monthly maintenance, full payment of direct expenses, and 100,000 Rand towards legal costs. The capital and the lease claims were dismissed. Our notable quote, folks, can be found on paragraph 13 of the judgment. Sight should also not be lost of the fact that the respondent is at present 67 years old and he is self-evidently close to retirement. He contends that the applicant is living a lifestyle that he cannot maintain. Find myself in agreement with these contentions on behalf of the respondent. As I have already indicated, the applicant's case is based on historical facts and circumstances and not on the present lived reality of the respondent, who is now a salary-earning employee nearing the end of his work life. I do not accept the applicant's contention that the respondent continues to spend money at whim. There is no evidence to support such assertions. This is HNC versus SJC in the South Gauteng High Court. Applicant getting partial success in the Rule 43, but several of her claims being dismissed for being based on historical realities and not present financial circumstances. A very interesting judgment if one considers the weighing up of our Section 7.2 factors. Next up, we stay in the South Gauteng High Court, Johannesburg, NSF versus RHF. This is Kruger AJ. Date of delivery, 2nd June 2025. Summary, page 7. Bundle, page 74. Now, once again, this is an interim maintenance claim coupled with a contribution to legal costs. Court deals with financial disclosure, shortfalls, community of property marriage, and the principle of equality of arms. Applicant wanted 25,000 Rand per month. This was previously paid by the respondent. Continued payment of household and child-related expenses and a contribution of 97,338 Rand and 85 cents, strangely specific, towards legal costs. Respondent claimed financial overextension, but acknowledged his ongoing financial contributions to the applicant and the adult dependent child born of the marriage. The court ordered 10,000 Rand monthly maintenance, sought 25, granted 10. The court granted 60,000 Rand costs contribution in 2 tranches. What was sought was 97,000. The notable quote by Kruger AJ in this matter is paragraph 29 of the judgment, which reads as follows. I'm not persuaded the respondent is in such dire straits as to be able to afford payment of the order I have in mind. For one thing, I find no plausible explanation as to the reason, nature, and extent of his alleged constrained financial situation, which has developed since the institution of the divorce. The various businesses he conducts are cash businesses. By its nature, the determination of income actually generated presents challenges and may be manipulated. The respondent has various income streams. No financial statements, whether audited or not, has been made available to the court or to the applicant. In addition, no tax certificates or tax returns are available. The respondent's disclosure, as recorded in his FDF, has been guarded, particularly in respect of his income he personally has or has access to for his use. Having regard to the respondent's various subpoenaed bank statements, the applicant's counsel argued it is likely the respondent is being coy as regards his actual available income and assets. I agree. On the face of it, the total income put forth by the respondent appears incongruous and understated, regard being had to the prevailing circumstances. This judgment I find particularly interesting in Rule 43, since we know in very a profound amount of matters, especially at Rule 43, a respondent would tailor circumstances where they convert previously EFT or bank account-based businesses to cash businesses to try and keep it off the books. What NSF versus RHF has done, in my view, from a reading of it, is turned it on its head somewhat. And the court, in doing so, has shifted the risk of the cash business, which is difficult to audit, from the applicant to the respondent, which I find a very, very interesting approach, and it will be nice to see if other courts follow this approach. That is NSF versus RHF, the risks of cash-based businesses, and that risk being moved to the respondent. Rule 43, once again, we have Domingo AJ. This is in the Gauteng Division, Pretoria. Citation is SZM versus MNM. The date of this judgment is 11 June 2025. On your summaries, you can find it on page 7, and in your bundle, you can find it on page 86. It is an interim maintenance claim for spousal maintenance and a child not born of the marriage. This was a blended family, and the court essentially had to determine the maintenance obligation of the respondent towards the child who was not their child. The applicant sought spousal maintenance of 14,000 Rand per month, child maintenance of 6,000 Rand per month for 3 children, only one of whom were born of the marriage, full care and guardianship, interestingly, and a contribution of 200,000 Rand to legal costs. Respondent opposed the relief, contesting the financial capacity and denying parental responsibility for the applicant's 2 children from a previous relationship. The case involved quite complex considerations of in loco parentis, the principles of customary law, and financial disclosure. In this instance, I will tell you folks what is held to give you an idea of the scope and ambit of the judgment and what we generally set out in the held section for the summaries. In this judgment, the court looked at Rule 43, obviously, Section 18.2 of the Children's Act, and the scope and ambit of parental responsibilities and rights. Section 28.1b of the Constitution, the right to care, the in loco parentis principle, consideration of customary law and blended families, ZADC versus ZADC for contribution to legal costs, interestingly, a very old judgment, MGM versus MJM, Van Rippen versus Van Rippen, EVG versus AJJV, in terms of equality of arms in litigation. Now, In the judgment, the court granted 14,000 Rand interim spousal maintenance, which is essentially what the applicant asked for. 3,500 Rand child maintenance for one child, and 1,500 Rand per month towards legal costs. I found this very interesting. The court did not peg an amount for contribution to legal costs, i.e. a once-off, this is your cost contribution. The court said 1,500 Rand per month in terms of a costs contribution. The court held that there was insufficient evidence of in loco parentis regarding the applicant's other two children, the children not born of the marriage, and dismissed those maintenance claims. The spousal maintenance claim was granted due to financial disparity between the parties, and a contribution of 1,500 Rand per month was granted, not the 200,000 Rand sought due to lack of substantiating evidence. Paragraph 74, folks, is our notable quote. In the case of N.M., the court placed great emphasis on the representations made by the step-parent to the family and society at large. The case brought to the fore the very complex issue of step-parent maintenance and indeed challenged the traditional understanding of parental responsibilities and rights. While I am of the view that one has to take into account the lived realities of modern family life, including customary family life juxtaposed with that of the common law position that a step-parent is not automatically subject to maintain a stepchild, while interpreting the concept of parental care as set out in Section 28(1)(b) of the Constitution as set out in 18(2)(a), (b), and (d) of the Children's Act, I am of the view that each matter must be decided on the facts before the court. In the premises, unlike N.M., as submitted and argued by the applicant's counsel in this matter, I find that there are insufficient facts before me to establish and consider the social and emotional bonds formed, particularly between the two minor children and the respondent, in order for me to find that the family is indeed a blended family and that the respondent took on the role of in loco parentis. Thus, the question of whether the respondent indeed agreed to a blended family, I will leave to the trial court. This includes the question whether the respondent assumed the liability to maintain the applicant's two minor children. Very interestingly, folks, the court did not close the door on the party to seek an order in respect of the alleged blended family or in loco parentis. The court simply said this is going to the trial court and every matter must be adjudicated on its own merits. And the MN judgment, obviously referring to the erstwhile judgment regarding maintenance for a stepchild or the child not born of the marriage, a step-parent's responsibility there. The court simply saying, don't throw out the baby with the bathwater. It must be in every instance down to the merits and the facts of each matter to determine whether there is in fact a maintenance liability on the non-biological parent or the step-parent. Right, that takes us safely out of Rule 43 land and into the realm of children's matters, of which we have 3 to go through today. It is now 20 to 9, and we are making fairly good time. Those of you attending the ZAM webinar, as I am also this morning, we should be done just before 10, so you will have time for a quick cup of coffee and a bio break before logging on to the ZAM webinar. Righto, next up we go to S.A.H versus S.B.H, South Gauteng High Court on the 5th of June 2025. Full bench, Wendell J, pending the judgment. Maya Frawley J, concurring. Mota J, also concurring. Summary, page 9 for those of you following along. Bundle, page 108. Now, this is a relocation matter, folks. It is an application or an appeal against execution pending the appeal under Section 18.3 of the Superior Courts Act. Whether there will be irreparable harm, the court looked at best interests of the child, procedural fairness, and the possibility of oral evidence. Quite a complex procedural judgment, but bear with me, we'll forge through. The appellant, in this case, the father, appealed against an order authorizing the respondent to relocate to Durban with the minor child. Very interestingly, folks, this is something that we are seeing more and more of, is these applications for leave to relocate in a national level. And I do encourage all of you to do some research on this. In terms of Section 18.3c, for an international relocation, all guardians must consent to the removal of the child from the Republic. This is not the case in a local type of scenario, but we are still faced, or the relocating parent is still faced with Section 31.2 of the Children's Act, that they must obtain the views and wishes of the other parent, and the best interest of the child standard underscores all of it. You cannot simply take your children and move to another province willy-nilly. So we are seeing quite a lot of these applications happening in one of two ways. Either, on the one hand, you have the applicant being the relocating parent seeking leave to relocate, or on the other hand, you have the applicant being the left behind parent seeking to interdict the relocation, as the case may be. So in this case, the father appealed against an order which authorized the mom to relocate to Durban, pending the outcome of an appeal challenging that very relocation order. So, relocation order was granted. Father took it on appeal. Mother then brought an application to execute, i.e. to move, whilst waiting for the appeal to be finalized. That was granted. The father appealed against that. So this is not the relocation that is being appealed against. It is the execution pending the appeal, i.e. mom can move whilst the appeal is being dealt with. The dispute followed mom's unilateral removal of the children from Gauteng, or child from Gauteng, and conflicting expert reports. The High Court then had to decide whether the court erred in granting execution of the relocation order under Section 18.3 of the Superior Courts Act. The appeal was upheld, folks. The interim relocation order was set aside and execution suspended pending the appeal. In other words, mom can't move pending the finalization of the appeal. The notable quote in this judgment is in paragraph 33 of the judgment, which was penned by Wendell J., and it reads as follows. In the circumstances, this court is not satisfied that the respondent has discharged the onus imposed by Section 18.3 of the Act. The fact that the matter concerns a child does not relieve the respondent of the strict burden imposed by Section 18. On the contrary, it calls for greater judicial caution. As the SCA affirmed in B versus S, in disputes concerning custody or access where allegations affect credibility and parental capacity, determining the child's best interest without testing the evidence through oral testimony poses a real risk of injustice. Courts must ensure that all relevant evidence, including that of the parties and the appointed experts, is fully ventilated and properly assessed. That was S.A.H. versus S.B.H., and that is in South Gauteng High Court before Wendell J., Maya Frawley J., and Mota J. Righto. Next up, we go all the way down to Durbs. W.S. versus NV. This is the KwaZulu-Natal division in Durban. The judge is G.J.T. The judgment delivered on 6 June 2025. Summary page 10 and bundle page 124. Once again, relocation. Best interest of the child, the constitutional rights of the custodian parent considered, expert evidence, family advocate's report, passport and visa consent, and obviously parenting conflict. So this is a relocation application. The custodial parent wanting to remove the minor son from South Africa to Portugal. The non-custodial parent, in this case, opposed the relocation, fearing the loss of bond with the child, understandably so. In this case, unfortunately, the parties had a long and convoluted history of litigation, and in this backdrop, the court had to determine whether the relocation was bona fide, reasonable, and in the child's best interests. The relocation, as we are seeing more and more, was granted. The father's consent for the relocation was dispensed with, and costs were awarded against the father at the end of the day. The notable quote in W.S. versus N.V. can be found from paragraph 43 to 44, which I will read to you now. In light of the evidence, the central issue which emerged is whether N's sole reason advanced for relocating, namely wanting to be with and live with her parents, is sufficient to meet the threshold of being bona fide and reasonable. Maya J.A. set out the test in the following manner in F versus F. While attaching appropriate weight to the custodian parent's interests, courts must, however, guard against too ready an assumption that the custodian's proposals are necessarily compatible with the child's welfare. The reasonableness of the custodian's decision to relocate, the practical and other considerations on which such decision is based, the extent to which the custodian has engaged with and properly thought through the real advantages and disadvantages to the child of the proposed move are all aspects that must be carefully scrutinized by the court in determining whether or not the proposed move is indeed in the best interests of the child. The court then goes on per G.J.T. after quoting Maya J.A. to say, the above extract makes it clear that while the approach of our courts generally favors a relocation application, where the custodial parent's decision is shown to be bona fide and reasonable, this is not because of the so-called rights of the custodial parent or the existence of any presumption in their favor. It is because it will usually not be in the interest of the child to relocate if that decision is not reasonable and bona fide. Notwithstanding the strong sentiments expressed in F versus F affirming the freedom of movement of a custodial parent, it bears noting that the court ultimately dismissed the mother's appeal seeking the court's consent to relocate. While the SCA found that the appellant's decision to relocate was undertaken honestly and in good faith, despite a genuine motivation, it nonetheless found that her decision was not as well researched and investigated as they should have been. There was a lack of structured plan for the relocation, with plans constantly changing and too many imponderables to enable the court to assess the likely effect of the move on the minor child. So in this instance, WS versus NV, the court considered in quite a bit of depth the judgment of F versus F per Maya J.A., balancing the interests of the parents and the child and contextualizing it for us quite nicely. Righto, let me grab a sip of my coffee and we will move on to our next judgment, last judgment relating to children, Reed J. South Gauteng High Court, and the judgment is AS versus RJ L.E. You can page your summaries, page 11, bundle page 158, while I have a sip of coffee. Fantastic. Now I'm fighting fit and rearing to go again. Let's move on. This is a urgent application surrounding primary residence for variation of a parenting order and the whole issue of a de facto change in care where the de jure amendment to the settlement agreement or parenting plan, as the case may be, was not attended to. It was a 19-month-old child born to unmarried parents. The father brought the urgent application seeking interim primary residence and care, citing mom's alleged alcoholism, violent behavior, and mental health. He relied on a de facto change in care arrangements when the mother voluntarily handed the child over to him in October 2024. The mother later came back and reclaimed the child under the earlier court order. In this instance, the matter clearly very acrimonious. Both parties had laid criminal charges against one another, and there were pending children's court and family advocate investigations, which obviously further complicated the matter. In this instance, the application was granted and the applicant was granted interim primary care. Respondent was granted unsupervised alternate weekend contact pending investigations. However, this was subject to various safeguards regarding the alleged alcohol use, etc. Paragraph 23 of our judgment, friends and colleagues, is the notable quote, which reads as follows. I interpret the above to mean that M's best interest should be the pivotal point of this whole application. The fact that two court orders in two courts determined the primary care and residence of M to be with the applicant is a factor taken into consideration, but not the determining factor that this court is to be bound by. In addition, this court should not bind itself to the formalities of variation, rescission, amendment of the existing court orders, but should remain focused on the best interests of M. Substance should take place over form, and in the interests of the minor child, the interests of the minor child should never be compromised by the legality of the variation, rescission, amendment of a court order dealing with M's best interests. The court preferring substance over form in this instance, and the applicant being granted interim primary care because the court deemed it to be in the child's best interests. Folks, I reckon we are about halfway with the roundup for this month. We've made pretty good time. It is now 10 minutes to 9. I believe we've got one more judgment for you before we go into the bio break. We'll break for about 5 minutes and then come back for the second portion of the family law roundup in time to be done before 10 for the ZAM webinar, which looks fascinating, by the way. Next judgment, last one before the break. DDB versus TDB and another. Western Cape High Court, Cape Town, Montame J. The judgment landing on 19 June 2025. Summary, page 13. Bundle, page 173. Now, this is a maintenance judgment regarding preservation of funds, best interest of the child considered, amendment of settlement agreements, finality of orders, and shared parental duty of support. So what happened? That seems like quite a lot. It was an urgent application by the applicant to preserve the proceeds from the sale of the respondent's immovable property to secure future maintenance for the minor child. The applicant alleged that the respondent's past conduct justified preserving the full amount of the proceeds of sale. The court was requested to amend clauses of a divorce settlement agreement that had been made in order of court. This was by the applicant. The respondent opposed the application, citing changed financial circumstances and a bona fide effort to meet his obligations. At the end, the court ordered a partial preservation of funds. The amendment of the settlement agreement was refused, and each party was ordered to bear their own costs. Notable quote, folks, paragraph 25 of the judgment per Montame J reads as follows. Despite the settlement agreement that was concluded on divorce, the court has not lost sight of the fact that both parents have a reciprocal duty to support their child. Section 15 of the Maintenance Act deals with the duty of parents to support their children. There is no requirement that a child should be supported by one parent more, especially if he or she has means to do so. The uncontroverted evidence was that the applicant owns a business as a professional accountant in addition to her employment with a group. No disclosure was made towards her financial circumstances. The first respondent, on the other hand, laid bare his financial circumstances. He confirmed that he was unemployed and said to be soon starting a business of hiring out some motorcycles to get an income. First respondent does not have vague business ideas, as it was in the case in Magewu. He has purchased a motorcycle, a Ford Ranger, with 2 trailers, with the sole purpose and in preparation of starting a motorcycle hiring business. On the other hand, what is sought for preservation is an undisclosed amount of money at the conveyances trust account, which in my view cannot cover all that the applicant claims for future maintenance of the child. DDB versus TDB and another Western Cape High Court, Cape Town, per Montame J. Righto, folks. Quick plug before we go into the adjournment. We're going to take a 5-minute break. As we do so, I do encourage those of you who have the means and the inclination to do so to please purchase our optional course pack at 300 Rand. It gives you our summaries. This month, 22 pages of summaries or 23 pages of summaries. Gives you the bundle of judgments referred to, and it gets you 2 SARM and social justice CPD points. As you have noticed, folks, I have not gone through the full summaries again this month. Unfortunately, we have caught wind of people recording our sessions, popping the recordings into AIs and then reconstructing their own notes, which obviously is quite damaging to our feasibility of running the family law roundup every month. As you can imagine, it takes quite some time to get our notes together. A good way to support us is to purchase the optional course pack. It's $300 and it gives you all of the latest family law judgments that I have been able to sniff out over various platforms within the South African courts. Reminder, please have a look at Civil Procedure for Family Professionals in respect of divorce, 9 and 10 July 2025, 5 SARM CPD points, 850 Rand, and this is intended to bridge the knowledge gap between theory and practice. As we all know, with the new directives coming in within Gauteng, the idea of mediation in a court-aligned and a court-annexed manner is very, very real, and we are all, as family professionals, going to have to start working together within an ecosystem. The reality is that this ecosystem, at least in terms of the new Gauteng directive, is very much rooted in context, and that context is civil procedure. For mediators, this is important. If you get a mediation under the directive, you need to know where you are in the process, what has happened, what has not happened, because that is going to set the tone for your mediation. So, folks, Civil Procedure for Family Professionals, Divorce, 9 and 10 July next week, 5:30 to 8 p.m. every evening. If you register, you get the slides, course pack, and various other resources. Finally, visit thinklegal.co.za for more information and for some resources. I am going to take a quick bio break. It is now 9 o'clock. We will be back at 5 minutes past 9, and then we will tackle the second round of the Family Law Roundup. I will see you all in 5 minutes' time. Alrighty, folks, roundup round two. We are back in action and ready to go. Can I have some thumbs up? Can everybody hear me and see my slides? Anybody? Dum dum dum. Lovely. Thank you, Pratima. Legend as always. Appreciated it. Right, let's go into round two of the Family Law Roundup June 2025. Next up, finally, late in the roundup, we go to the Eastern Cape High Court in Mthatha and our Judge Mhambi AJ, ZM and another versus AF and others. This is 5 June 2025, summary page 14 and bundle page 185. And this is a fascinating judgment. I'm going to go through the whole judgment or my full notes for this judgment. So listen up, folks. It is a paternity dispute, and the matter revolves around DNA testing in the context of a deceased estate and an order that was sought to exhume the body of the deceased for the purposes of DNA testing. The essence of the judgment revolves around the community mores and judicial discretion in respect of these types of matters. So here's what happened. The applicants sought an order compelling the respondents to undergo DNA testing to determine whether they are the biological children of the deceased who had a known relationship with their mother. The respondents had lodged a claim against the deceased's estate and insisted that a DNA test be performed on the exhumed remains, i.e. dig up the deceased to do the DNA testing. And then the applicants obviously opposed the idea of the deceased being exhumed. The court had to determine whether adult persons could be compelled to undergo DNA testing, and secondly, whether exhumation was justified in this instance. The court looked at various very interesting factors. First off, judicial power to compel DNA testing in adult paternity disputes. The court had to balance up truth-finding and personal privacy, C.T.L versus Pravitha and another N.O. Public policy and moral considerations regarding exhumation, and that is the court considered King N.O. versus Diacher and others. It looked at principles regarding joinder, looked at principles regarding condonation, and it looked at Section 36 and 37 of the Children's Act, but it distinguished these things because the parties were all adults. The court ordered the respondents, the adults who had lodged a claim, to undergo DNA testing. However, the request for exhumation was refused. Here's what was held. The court has the inherent power to compel DNA testing in the interest of justice. While the pursuit of truth is vital, this must be balanced with public morals. Exhuming the deceased was deemed a drastic and unnecessary measure where alternative DNA sources were available. Thus, the respondents' insistence on exhumation was rejected by the court. Paragraph 14 to 16 are our notable quotes here. The applicants are suggestive that the DNA test concluded or conducted without the deceased remains is sufficient to prove paternity that is an issue between the parties, a point the opposing respondents disagree with, and suggestive that the DNA test conducted on the remains of the deceased will be reliable and provide the truth. Even though this court is concerned with the administration of justice and that the truth and only it gives an end to legal controversies, this covet need not give an order compelling drastic relief in circumstances when less drastic measures or remedies are available. There's a typo in the judgment, folks. Apologies. In paragraph 15, you'll see on your notes, there's this, it's this court need not give an order. I think there was a typo in the text on the judgment. And then paragraph 16, an order a court should make must be in the interest of justice and not against public morals or contra bonos mores. An order that compels the doing of a drastic action is similar to the one that is contra bonos mores and against public morals. An order that compels the doing of a drastic action is similar to the one that is contra bonos mores and against public morals. That is ZM and another versus AF and others. Well worth a read, even if you have the summaries. Summary page 14, bundle page 185, Mhambi AJ. Incidentally, once in every roundup, I do say this, folks, you'll see it on your summaries as well. These summaries and the roundup is intended for informational purposes, and it is intended to fast track you into reading the judgments yourself. The summaries can't, under any circumstance, encompass all nuances and aspects of a judgment. Judgments are a certain length for a reason. They shouldn't be relied upon as a comprehensive source. Nuance will get lost in summaries. So if you intend to rely on anything, on any of these judgments, use the summary to fast track you into understanding the judgment, and then read the judgment yourself. That bears saying, but I suppose in a world where we have lawyers left, right, and center being targeted for AI usage or nailed for AI usage, it bears repeating. Right. Consult the full text of the cases if you intend to use them for professional purposes, obviously. Right. Next up, CWB versus CEB. That is South Gauteng High Court, Johannesburg, 18 June 2025, Bonds AJ. Summary page 14, bundle page 196. This is a accrual, oral agreement, Rule 11 consolidation, and essentially whether a divorce and a commercial matter should be consolidated into one action. So the applicant brought an application to consolidate a divorce and a separate claim for the enforcement of an alleged oral agreement relating to divisions of proceeds from the former matrimonial home. Divorce action was undefended. The matter regarding the matrimonial home was defended. So the court had to determine whether it was convenient and appropriate to consolidate the matters. Court said, nope, it is not convenient. The application was dismissed, and the notable quote reads as follows. The divorce action is undefended, and a decree is presently ripe for the taking. Consolidating the actions at this stage would effectively put the divorce action on ice and shackle it interminably to the opposed oral agreement as it wends its way through the court process. An uncontested divorce would be held hostage by a separate financial dispute between the parties. During that time, the parties would remain in limbo, still married and unable to move on with their lives. The prejudice to the parties, to their 17-year-old son, and to the administration of justice is evident. That is CWB versus CEB in the realms of procedure, and that deals with consolidation of actions. Next up, we stay on procedure, and interestingly, we have 5 judgments on procedure this month. Next one, we go down to the Western Cape High Court, the Court of Lekuleni J, judgment delivered on 19 June 2025, summary page 15, bundle page 205. This is the judgment of SP versus SB, and this deals with a fantastically interesting topic, and that is the issue of subpoena duces tecum, which, as we know, is a subpoena to get documentary evidence from a third party. So one would, for example, issue a subpoena duces tecum against a bank to get bank statements of a party to the litigation. Now, what is interesting here is the subpoenas were issued in the context of motion proceedings, and the issue was whether you could issue a subpoena duces tecum in motion proceedings. These are usually used in trials. The applicant approached the court to set aside the subpoena, which was issued against his employer by his ex-wife for financial documents. The applicant said, no, you cannot issue a subpoena. These are motion proceedings. They are not trial proceedings. The court had to determine whether the subpoenas could be issued in motion proceedings. Now, very interestingly, the matter implicated the financial interests of two children, one minor, the other one a major dependent. And the court, in this backdrop, had to decide whether the subpoena duces tecum issued in the context of motion proceedings should be set aside as irregular, because subpoenas, in terms of the rules of court, are for action proceedings. The court held, and I'm going to share with you one paragraph of my held, although the subpoena was issued under an incorrect rule, this technical defect should not override the imperative to determine the matter on its merits, particularly where the best interests of the children are concerned. The court declined to set aside the subpoena. The application was dismissed, and each party was to pay their own costs. Paragraph 20 is our notable quote on this judgment by Lekuleni J. Most importantly, this matter centers around the maintenance of a minor child and a dependent child who is at a tertiary institution. As the upper guardian of minors, this court is empowered and under a duty to consider and evaluate all relevant facts placed before it, with a view to deciding the issue which is of paramount importance, the best interests of the child. This case, in my view, cannot be divorced from the well-established principle that in all matters concerning the care, protection, and well-being of a child, the standard that the child's best interests of paramount importance must be applied. The interests of the minor child should not be held at ransom for the sake of legal niceties and formalism. The interests of the children must be considered within the wider context of an objective regard of all relevant factors. Simply put, the centrality of the child's best interest in a case such as this must guide the court in decision making. Best interest of the child, paramount importance. For this reason, the court declines to set aside the subpoena duces tecum allegedly issued improperly under the rules of court. That was, of course, the judgment of Lekuleni J. SP versus SB. Next up, we go to the Northwest High Court in Mahikeng, and this is a judgment by Masike AJ of K.P.M versus O.L.M and another, and this is on page 16 of your summaries and page 214 of your bundle. Deals with the variation of a divorce decree under Rule 42, and essentially what happened here is the applicant sought to vary a final divorce decree which was granted all the way back in 2013, arguing that the court had incorrectly treated the marriage as out of community of property, when the applicant alleges that it was in community of property. The variation was brought under Rule 42(1)(c) of the Uniform Rules. Applicant contended that the judgment had been granted due to a common mistake between the parties, or a mistake common to the parties. The original action was instituted by the applicant's late husband, was fully tried, and the issue of patrimonial consequences had been determined based on the parties' pleadings. Then at a later stage, obviously, the applicant sought to vary it. Unsurprisingly, the application was dismissed with costs on a party-and-party scale, including Scale A counsel fees. Paragraph 23 of the judgment is instructive. The function of judicial officers is to determine the issues before them and to confine themselves to such issues. It is for the parties to set out and define the nature of their dispute in the pleadings, and the court to then adjudicate on the issues so defined. It is not for the judicial officer to create new factual issues. The matter is determined on the parties' pleadings. The court does not go on a frolic of its own and create additional issues. That, of course, the judgment of K.P.M versus O.L.M and another in the Northwest High Court, Mahi King. Next up, we go back to the South Gauteng High Court in Johannesburg, judgment by von Ludwig A.J., 12 June 2025, S.A.T versus G.J.T and others, summary page 17, bundle page 2024. It is a divorce. It's an interlocutory application, joinder of subpoenaed witnesses, Rule 30, and costs on an attorney-client scale. So, here is the lowdown on this matter. Matter arises in the context of a divorce action. Applicant had filed an application to compel the first respondent to comply with the Rule 35(3) notice, further and better discovery, obviously, and sought compliance from the second and third respondents who had subpoenas served upon them. The latter respondents, though not parties to the divorce proceedings, brought an application in terms of Rule 30 sub 1 to set aside the application to compel and the accompanying affidavit. The court dismissed that application and awarded costs against them. This is those respondents' leave to appeal application. Right. So as we said, the respondents are the parties who had been subpoenaed. They had sought to set aside the application to compel and the accompanying affidavit thereto. That application was dismissed and they were awarded, or costs were awarded against them. They then brought an application for leave to appeal. The application for leave to appeal was dismissed with costs on an attorney-client scale, and the court says the following at page 14. Paragraph 14, not page 14, sorry, paragraph 14. I disagree that an appeal is necessary because my judgment conflicts with the judgment of Goosen J. and Makeda. This conflict requires resolution. My statement in my judgment that the facts of Makeda are so materially distinguishable that I find it of no bearing explains why the Makeda principle is not relevant or applicable in this case, and why the judgments of Goosen J. and I do not in fact conflict. Makeda, as I said in my judgment, dealt with the wife herself trying as applicant to join an interlocutory application when she was not a party to the main case. Here, as respondents, we have witnesses who have received and apparently ignored subpoenas being brought by one of the litigants into an interlocutory application in the main case to procure their adherence to documents served in the main case. There is no parity of reasoning by which, as respondents contend, the Makeda principle can be applied to the case in hand, where their facts and the results to be achieved are so materially distinguishable. The judgments are thus not conflicting, and thus no need for another court to resolve conflicting, open quote, close quote, judgments. That is S.A.T versus G.J.T, application for leave to appeal by the respondents, dismissed with attorney-client costs. Next up, we stay in the realm of procedure. South Gauteng High Court, Johannesburg, Lange A.J., NS versus A.D., 20 June 2025. Summary page 18 and bundle page 232. It is an interlocutory application under Rule 30 Cap A in respect of a replying affidavit. What happened is as follows. Proposed interlocutory application brought under Rule 30 sub 2 sub B and Rule 30 capital A of the Uniform Rules. The applicant sought to set aside a notice of motion and paragraph in a replying affidavit filed by the respondent in a counter application concerning the termination of parental responsibilities and rights. The respondent's replying affidavit was filed 6 months late and 9 court days before the scheduled hearing without the required condonation or proper procedural compliance. The court had to determine whether the respondent's steps were irregular and what relief to grant. In this instance, the court set aside the respondent's notice of motion. The applicant was granted leave to file a supplementary affidavit. The costs, interestingly, were to be borne by the respondent's attorney. And I focus on that portion in our notable quotes, paragraph 29 to paragraph 32. Whilst the reading of the affidavits and annexures filed tell a tale of two attorneys locked in combat, that is not reason enough to overlook the fact that this application could have been avoided had the respondent's attorney of record taken a more common-sensical approach. I see no reason to burden the respondent with a further costs order, especially where she is reliant on the advice of her legal representatives in the conducting of her application. At the same time, bearing in mind the dicta and multi-links, I'm not convinced the applicant has satisfied the requirements for a de bonis propria costs order against Mr. A. He has not, in my view, acted in a manner that shows dishonesty, obstruction of the interests of justice, irresponsible and grossly negligent conduct, litigating in a reckless manner, misleading the court, or gross incompetence. At the same time, I am cognizant of the respondent's dire financial situation and see no reason for her to be burdened with costs which could have been avoided. She has stated under oath that Mr. Armstrong is acting pro amico, but that she had to engage counsel to finalize her replying affidavit. She does not take this court into her confidence regarding the costs for opposing the application and what, if any, she has had to bear. There can be no doubt that the subject matter of the main application is a serious one, and the best interest of the party's minor child is best protected when both parents are ably represented. In the circumstances, I am of the view, insofar as Ms. M has charged fees for the present interlocutory application, the respondent should not be burdened with the cost thereof, and such costs are to be paid by the attorney. Very, very interesting judgment, and very interesting the distinction between a de bonis propria costs order and the order made here. Go and read the judgment for more information around that. Very, very interesting judgment regarding the apportionment of costs in applications where there has been conduct by an attorney which does not comply with the requirement of being commonsensical in approach. Very interesting judgment. NS versus AD, Langer AJ, summary page 18, bundle page 232. Next up, we go into the realm of customary marriages. We've got 3 this month, and we go into the Eastern Cape High Court and Mpumalanga High Court and Limpopo High Court. 4 more judgment to go, friends, before the family law roundup concludes for this month. NN and others versus BN and others, Eastern Cape High Court in Tata, 5 June 2025, Mhambo AJ, summary page 19 and bundle page 243. This deals with the dissolution of a customary marriage and whether desertion is sufficient for dissolution of a customary marriage. So the first applicant entered into a customary marriage with a deceased in 1978. They approached the court to have the subsequent civil marriage between the deceased and the first respondent declared null and void. The customary marriage was never legally dissolved, and although unregistered, it was valid under customary law. The deceased later married the first respondent in a civil ceremony in 2017, allegedly without the applicant's knowledge or consent. The court had to determine whether the separation or repudiation dissolved the customary marriage, and what then follows is whether the civil marriage was legally valid, which it would not be if the customary marriage was not dissolved. In this instance, the court found that the customary marriage had not been dissolved by desertion and or repudiation. A decree of divorce was necessary. And in this instance, the civil marriage declared null and void. The customary marriage was declared valid and to be registered. Paragraph 34 is instructive. The RCMA is clear that a customary marriage is dissolved by a court by a decree of divorce. Absent decree of divorce issued by a competent court, a customary marriage subsists and remains valid. In this case, there is no decree of divorce dissolving the bonds of customary marriage between the deceased and the first applicant. Clearly, the customary marriage does not dissolve because the parties to it feel it is irretrievably broken down. It is the court that must be satisfied, having considered relevant factors, that the relationship between the parties has reached such a state of disintegration that there is no reasonable prospect of restoration to the normal marriage relationship between them, whereafter the court issues the decree of divorce. That was NN and others versus BN and others, Mthatha High Court, Eastern Cape. Next, we go to the Mpumalanga High Court in Mbombela, Rachivumo, D.J.T, presiding N.R.M versus FN and others. Summary page 20, bundle page 257. This is a matter regarding the validity of two marriages entered into by the deceased. The applicant alleges a customary marriage in 2017. The deceased later entered into a civil and customary marriage with the first respondent without the applicant's consent. After the deceased's passing in 2023, both women claimed spousal recognition and entitlement to his estate. The court had to determine the validity of both marriages and the rights of the respective spouses. The applicant had her marriage declared valid, whereafter the first respondent's marriage was declared invalid and unlawful. Paragraph 13 to 14 are our notable quotes in N.R.M versus FN. Nothing comes out of the argument to the effect that the deceased's marriage to the applicant was irretrievably broken down. Even if this was a fact, it does not on its own validate the purported later act of marriage. The fact that the marriage could be irretrievably broken down only entitles the parties to that marriage to seek a divorce decree, which can only be granted by the court, echoing the sentiments, obviously, of Mhambo AJ in the Mthatha High Court, which we just dealt with in the last judgment. If a party does not seek divorce upon realizing that his or her marriage is irretrievably broken down, they cannot claim and utilize the rights and benefits that accrue with being a divorcee, such as the right to enter into a new marriage. Very importantly, only a court can grant a decree of divorce. That, of course, was N.R.M versus FN and others in Mpumalanga High Court. Our final customary marriages judgment for the roundup. This comes from the Limpopo division in Polokwane, a bench consisting of Mangena A.J., Kanyago J., and Ngobeni J. Mangena A.J. penning the judgment, and both Kanyago J. and Ngobeni J. concurring with the judgment. This is L.M.P. versus N.J.D.P. appeal, summary page 21, bundle page 268, and date of judgment 19 June 2025. This is an interesting case because it deals mostly with procedure, but I have put it for convenience sake with customary marriages because it's a very specific procedure when it comes to customary marriages. And this is proceeding on a stated case regarding the customary marriage existence or not. Appellant alleged she was married to the respondent by way of a valid customary marriage on 10 January 2015. Respondent denies this. The parties, he alleges, were validly married out of community of property on 23 October 2015 following the execution of an ANC. So the issue is customary marriage, ANC, civil marriage, which one takes precedence? Now, the trial court was asked to determine the existence of a customary marriage under RCMA, but the proceedings were derailed by the parties attempting to proceed by way of an informal stated case without proper compliance with Rule 33 and 33.1 and 2 specifically. The full bench then considered, or the three judges sitting as an appeal court of the High Court, considered whether an appeal should be granted against the finding of the court a quo on the stated case, or the informal stated case as referred to in the judgment. In this case, the appeal was upheld. The matter was remitted for oral evidence on the existence of a customary marriage. Mangena AJ and the other two judges concurring, taking the view that oral evidence is required to determine this issue and that it could not have been validly decided on a stated case. Paragraph 15 to 17 reads as follows. As stated in paragraph 11 above, the parties had already agreed that there was a customary marriage concluded on 10 Jan 2015. Once the parties agree on an issue, it is no longer open to the court to determine it. This is so because the court does not adjudicate on issues which are no longer of practical effect to the parties or do not present a live controversy between them. Had the parties prepared a written statement of facts by Rule 33, the court would have been enlightened about the nature of the dispute and exercised its judicial discretion whether to allow the parties to discontinue the leading of oral evidence. As I see it, the central issue for determination, notwithstanding the imperfect stated case, is the validity of the alleged customary marriage. This issue cannot be resolved by way of stated case. It required the parties to present their evidence in the absence of agreed facts. This is LMP versus NJDP, highlighting the dangers of proceeding with a stated case in respect of validity of customary marriages. And then finally, folks, we go to a judgment previously covered in the Family Law Roundup, which I put in because it has now been reported in the 4th volume of the SA Law Reports of 2025. This is Ex parte EW and others, the judgment of Neukircher J regarding surrogacy, summary page 22 and bundle page 277. A fascinating judgment on the ex parte application of the parties to have a surrogacy agreement made, an order of court, which was ultimately refused by Neukircher J inter alia on the grounds of domicile and a scant setting out of facts by the parties. And that is then ex parte EW and others, which has now been reported in the Law Reports 2025 for SA 211. Folks, that takes us to the end of the Family Law Roundup for June 2025. Thank you so much to all of you who attended this morning, despite the early start. The early birds in this instance do get the proverbial case law worm. Once again, a reminder and appeal to those of you who are inclined and able to, please purchase our course pack. Gives you the summaries, bundle of judgments. You will note it's just under 300 pages of judgments, which I've paginated for you. Our summaries, 23 pages of summaries, and then 2 social justice or SARM CPD points. Reminder for those of you who are not yet on board, next week's civil procedure for family professionals, divorce, 9 and 10 July 2025, 5:30 to 8 o'clock, 5 SARM CPD points, 850 Rand to attend. That, once again, is designed for mediators, candidate legal practitioners, mental health professionals, and legal practitioners who seek a better understanding of divorce processes. The 5-hour training bridging the knowledge gap between academic knowledge and procedural knowledge in divorce matters. From my side and all of us at the ThinkLegal team, thank you for attending the roundup today. For those of you who purchased the course pack, please do reach out to me and let me know what you think of the new format. I really do appreciate all of your feedback, and it helps me to make the roundup more relevant and better for all of you. In closing, go to thinklegal.co.za. You can get all of the resources referred to and buy tickets for the upcoming civil procedure training. That's it from us. Thank you once again, Lawbox, Vermeulen Attorneys, for the support, and thank you especially for all of you for attending the Family Law Roundup. I'm ending the event now, and I hope to see you at the next one soon. Thank you once again, everybody. Have a fantastic weekend. Keep warm, keep safe, and see you next time.